Hi, I'm Diane Drain, bankruptcy attorney and law professor. I want to talk about what happens at the meeting of creditors. That sounds pretty ominous, doesn't it? Like a whole bunch of creditors going to show up and be asking you questions. Well, the meeting was really designed in a much earlier age of bankruptcy, where there actually were meetings of creditors, and creditors voted whether or not to grant a discharge. That doesn't exist anymore, but the name has followed with it. Now, we'll say to you that some creditors do show at some of these meetings, but for the most part, what will happen in the consumer world will be that the individual and their spouse, if they're married and filed together, will appear. The trustee will be there. The trustee will ask them to swear under oath that they did review the documents, that they're true and accurate, ask them how long they've lived in Arizona or where they lived before Arizona, and then ask them specific questions about assets, transfers perhaps, money paid to others, looking at the bank statements. What have they done with some of the larger withdrawals from those bank statements? And then the trustee may ask them about tax refunds. In Arizona, refunds are not exempt. May ask them about transfers that they've made to other people. Usually, though, if the bankruptcy documents were accurately prepared, in other words, you used really good bankruptcy counsel and you were really dedicated to getting good information on those documents, then that meeting is typically 2 to 3 minutes long. I don't want to make light of it. It's terribly, terribly important. But if the homework is done properly, it should be a fairly quick meeting. Now, if a creditor is there, they do have the right to ask certain questions. Then they may be just asking questions related to the debt. If the creditor carries on too long, though, the trustee will shut them off and tell them that the creditor has every right to continue with their questions, but in a form of what's called a 2004 exam. That's not going to be held that same day. That's going to be sometime later. So back to the actual meeting with the trustee. Once you're through answering those questions, oh, by the way, make sure you bring your driver's license, Social Security cards. Please don't forget that. That could end up resulting in a postponed meeting, and then if you've got an attorney, they're going to have to come back down. And like with our firm, unfortunately, we have to charge another fee for going back down because our clients forgot to do something. Now, prior to that meeting, though, the trustee will have sent the debtor a list of documents that they need. Certain number of bank statements, tax returns, maybe pay stubs, driver's license, registration on vehicles, if they have businesses, information about the businesses. It's very, very important that you get that information, all of it, to the trustee within the time frame that the trustee requests. If there's some small document that you weren't able to give the trustee, make sure you bring it with you to your meeting with the trustee. So, I don't want you to be worried about the meeting, but it is important that you be prepared. Make sure you dress appropriately, too. You are going to a federal courthouse. Okay, well, I hope that was helpful. You take care.